All right, all right, all right. Hey, what's up? What's up? What's up? It's your girl, Neek, and you're tuned in to Neek at Night. And tonight we're going to be hearing the appellate argument of Tory Lanez in this Meg Thee Stallion case. And basically, he is going up to try to argue so that he can try and get another trial and another go at this.
Matter number 23, People versus Peterson.
All right, this is the Tory Lanez argument, you guys.
Good morning, Your Honors.
All right, so let's hear.
All right, your panel on this matter is Justice Edgerton, Justice Adams, and myself. You have requested 30 minutes of oral argument. Do you want to reserve some of that time for rebuttal?
5, please.
All right.
If I may please the court, my name is Crystal Morgan with Morgan Legal Services. I am co-counsel with Unite the People, Inc. and the Baez Law Firm for Mr. Daystar Peterson, who is the appellant and the defendant. We wish to begin by acknowledging the harm expressed in this case. For those that were affected, our arguments today are presented with the unwavering belief that our client, Mr. Peterson, is innocent, with the utmost respect. It's important as we would like to clarify that any display of empathy should not be considered an admission of guilt. That guilt is established in the bedrock of our criminal procedure that is from the prosecution. And in this case, that was riddled with numerous errors. That standard was not met. We believe the most compelling arguments are the testimony of Ms. Kelsey Harris when looking at the confrontation clause, prosecutorial comments in the opening and closing statements, and Brady violations that cumulatively occurred throughout the trial. To start with the confrontation clause, particularly with Ms. Harris, who was present in court and also present on the night in question with Mr. Peterson, Ms. Pete, and Mr. Smith on July 12th, 2020. Ms. Harris gave testimony on December 14th and 15th. These dates are important to note, but she only gave that testimony after asserting her Fifth Amendment rights. With the confrontation clause, what we must do is a very fact-specific analysis, and we must weigh Ms. Harris's right to not self-incriminate with Mr. Peterson's right under the Sixth Amendment to confront those witnesses. Because of this, we have to analyze this and take it step by step. So the first step is seeing if we have a testimonial statement. And this is according to Crawford v. Washington, 2004, 541 U.S. 36. These statements were further defined whether to be testimonial or non-testimonial by the High Court in Davis v. Indiana, which is found at 547 U.S. 813 in 2006. Statements are testimonial when the emergency no longer arises, when the statement is being given in response to a future prosecutorial event. So we know that Ms. Harris, when she gave her interview with the district attorney's office, was giving a testimonial statement. Therefore, the first prong is met. But the second prong is not so easy to establish. We need to determine if Ms. Harris was available or unavailable, which is a little tricky in this case, which is why we need to walk through each step. So Ms. Harris walked into court and said, "I exercise my Fifth Amendment right." That made her unavailable. But when they granted her use immunity, she was thereby available again. Yet she still got on the stand and testified in a manner that was not consistent. She said, "I don't remember." Or she said, "I was dishonest in my interview with the district attorney's office." Therefore, because of the way she was testifying, they decided at first to take this interview, which at the time we did not have a transcript for. And they were playing portions of the recorded statement to refresh her memory that the jury heard. So at first, that was going on in her direct. then in her cross-examination, as she continued to testify in this varying manner that wasn't the way everyone expected her to testify, they entered the entire recording into evidence. But that recording was not entered into evidence while Ms. Harris was giving her testimony. It was entered into evidence on December 16th. And at that point, this is when the defense received that transcript, which we argue not receiving that transcript was a violation of Brady, and it also was a violation of Penal Code 1054.7, Your Honors. So we have this now statement in evidence, which is a transcript of a testimonial statement given to the prosecutors. In order to get this into evidence, they have first argued that they were going to use it to impeach Ms. Harris. This is because in their opening statements, the prosecutor said that Ms. Harris was going to testify that Mr. Peterson had violently pulled her by her hair from the car. This is a fact that was not proven at trial. Ms. Harris did not testify to this. Therefore, we feel that also is one of the inappropriate opening arguments. But additionally to that, we strongly objected to the late discovery of this transcript. And it wasn't just the late transcript. There were numerous other instances that the trial attorney did object to. But nonetheless, ultimately, the court did admit this statement under both Evidence Code 1235 and Substantive Evidence, Evidence Code 770. So now it's in, and we have a very unique situation here where we have a testimonial statement. We have a witness that doesn't want to give us answers and is saying I was mistruthful in my interview only in September of 2022, and this trial was in December of 2022. So it's clear that she did not want to cooperate. She said as much on the stand, I don't want to be here today. As a result, these matters, we feel that we need to look at the reliability and the prejudice to Mr. Peterson. And as Ms. Harris stated, I didn't tell the truth. So we can't rely on these statements from her own words. And this did greatly prejudice Mr. Peterson because in that interview, Ms. Harris said, my friend and I were attacked and it was this man's fault. And then at trial, she did not verify those statements, but the jury still heard those statements nonetheless. And we know that the jury relied on these statements because during deliberations, they did ask for a copy of that transcript to further analyze it. Therefore, we feel that the totality of this circumstance really does show that Mr. Peterson didn't have a chance to confront that witness in the Sixth Amendment context. Additional errors occurred throughout opening and closing statements. Start with the opening statements. We heard the prosecutor promise that he was going to put Mr. Justin Edison on the stand and that Mr. Edison would say that the following day when Mr. Peterson met with him to give Ms. Pete and Ms. Harris's belongings to him, that Mr. Peterson confessed that he did this crime. So the jury in opening statements at their first introduction to Mr. Peterson heard, he's guilty and he said so, and I'm going to put a witness on the stand to prove it. But Mr. Edison never testified in the trial. Mr. Edison was not being cooperative with the prosecutors. In fact, in November 28th, 2022, the court had to put a body attachment onto Mr. Edison. And on December 5th of 2022, Mr. Medesian, our trial attorney, actually filed a motion in limine specifically for this. And he stated that he was very concerned that Mr. Edison not coming to court would severely prejudice Mr. Peterson. And he urged the court to not allow such statements in opening. This motion was not granted. And so the court heard that Mr. Edison was going to testify. When Mr. Edison didn't show up due to media coverage and comments made in the trial, it was implied that Mr. Peterson was responsible for Mr. Edison not being in court with no proof of such contentions, which further prejudiced the jury. The body attachment continued at that point, and he still did not cooperate with the prosecution. We know in California, due to Hawk v. Superior Court, which is found at 42 Cal App 3D 108 in 1974, this is the controlling case that supports the contention that opening statements are confined to a reasonable good belief of what the prosecutor feels he will be able to show in the trial. Reasonable good faith, arguably, very respectfully, is not having a body attachment on a witness. The witness may or may not be trying to avoid the process. We don't know. He's just not there. And so that's all we can rely on. And ultimately, what happened is exactly what Mr. Medesian was afraid of in his motion in limine. And what Hawk warns about is that we must have this reasonable good belief in these opening statements to promise something, especially when it comes to a confession, because the jury is going to believe the prosecutor. They're going to rely on those words and have the prosecutor guide them and direct them to show why Mr. Peterson was guilty. So because of the great weight that the jury naturally gives the prosecution, we feel that these statements were inapposite to a good faith belief. Generally, a court would give a limiting instruction and attempt to cure such a situation. But in Mr. Peterson's court, no such instruction was given. There was no curative instruction for these opening arguments.
Let me ask a question here. So are you arguing that any time a witness is subject to a body attachment, that any reference to that witness should be off limits in opening statement?
I think that the prosecutor should be extra careful in such a situation because they're going into this knowing that that witness is not cooperative. So I think that if they say that they hope to produce such a witness, that perhaps would be enough. But here, there was just no hesitation. And I think it's especially true in the case of the evidence that we're dealing with Mr. Peterson, that it was a confession.
And so what was the evidence or indication that the people did not have a reasonable good faith belief that they would be able to produce Mr. Edison at trial?
We actually have no proof of the district attorneys ever speaking to Mr. Edison. The defense was never provided of a copy of any interview that they conducted on this witness. We have no physical evidence. All we have is an email from the district attorney in this case that said, I didn't disclose this and I meant to disclose it, but we are going to call this witness who will say that Mr. Peterson confessed to him. So I honestly, despite my best investigations, we cannot find where this statement came from. We cannot ascertain the veracity of these statements. That's why I think it's inappropriate. I don't think it's always inappropriate. But in this case, with these particular facts, I do feel that it's inappropriate. And there was also problems in closing arguments, which contained inaccuracies, and it presented the evidence in a way that misconstrued the actual results. Here, I'm specifically talking about the DNA evidence. So we heard the prosecutor close the case by telling the jury, don't be fooled when we hear that Mr. Peterson is excluded. But that's not exactly what the evidence said, which they had in their possession. I feel that statement really misled the jury. It may have confused them. It played on their emotions. And we know that that's not appropriate in closing statements. And in order to really understand the weight of that statement in closing, we need to understand what the evidence was that the district attorney had available to them. So as shown in our brief, in our reply brief, as for the magazine, there were 4 DNA profiles discovered on the magazine, none of which that were Mr. Peterson. Therefore, he was excluded from the magazine. As far as the firearm goes, they also found 4 different samples, one of which was a 90% male contributor. But Mr. Peterson was excluded from being that 90% contributor. Therefore, telling the jury, don't be fooled when you hear he's excluded is just not quite as the evidence showed. And to illustrate this, I want to clarify some key terms in science. So inconclusive, we heard in trial testimony, means it's not positive, it's not negative, it's just a neutral result. But it's not quite as simple as that. Actually, according to the scale of a likelihood ratio, which was in the discovery and presented at trial, likelihood ratios are the percentages. And we did not hear any percentages in Mr. Peterson's case, even though this evidence was available to the prosecution. This evidence was only given to defense upon our expert witness's request. So we did receive this evidence late. So this evidence was not presented in trial. It was presented in the motion for a new trial. But what we can see is that likelihood ratios that are 0, 0.01 and below are considered to be excluded. Likelihood ratios from 10,000 to 999,099 are very strong, very strong support to the prosecution that this person did leave DNA on this item. And then above 1 million is very strong. We found in the DNA evidence that they labeled Mr. Peterson's LR to be inconclusive and uninformative. And uninformative, according to this scale, is this an LR of 1. Therefore, Mr. Peterson had an LR of 1 in a million that his DNA was on this firearm. And with that fact, it is actually marginally more likely that another member of the African American population touched this gun over Mr. Peterson, which the jury did not hear. The jury heard the district attorney say, "Don't be fooled." But there's also no proof that Mr. Peterson did anything to fool anyone about this evidence. He presented his defense. It was their testing. We went off of what their testing said. So I just think that is a very strong contention. People v. Berryman in 1999, 21 Cal 4th to 50 is a significant California Supreme case that addresses the standard for overturning a conviction due to prosecutorial misconduct. It's a principle. Basically, the key outcome of that case was that we must show that this misconduct materially affected the outcome of the trial. And it did, because if our jury had heard that Mr. Peterson, maybe 1 in a million, touched the gun, I believe that would have been enough to tip that scale and show reasonable doubt for them to find him not guilty. The jury just didn't hear that. They heard that Mr. Peterson hoped that they would be hoodwinked. in the alleged closing arguments. So due to these statements and the misconstruing of the evidence, we feel that that was a very significant issue in the case. And finally, we feel that the Instagram post, as we discussed in our opening brief, this was a Brady violation. This post was given not only late, but it also was not redacted. It was riddled with hearsay. This post is significant as it also implies a confession, because what we have is actually various people posting, and this was in September of 2020, and they were posting that people were saying that, oh, well, if Mr. Peterson didn't do it, then Ms. Harris must have done it. And Mr. Peterson's social media manager commented on this post, no, they're not. And so that was used as an admission. But many celebrities don't run their own social media accounts. This is significant because, number one, had that discovery been given timely, we could have provided the statement that was provided in the motion for a new trial by Mr. Farias, stating that he is the one who runs Mr. Peterson's social media account. He made that post, and he didn't ask Mr. Peterson before he made that post. So that right there, we could have, if it was not late, presented a defense. But because we didn't have that, we were caught off guard. We were always in a position of reactive instead of actually being able to produce a good defense on this case. The Brady rule provides...
Let me just ask one question at one thing you said.
Yes.
Were there requests for redaction of that exhibit or the post?
I believe there were, yes. Mr. Medesian did do a very good job objecting throughout the trial. We also must remember that Mr. Medesian only took over this case 2 weeks to a month prior the start of the trial, because the first trial attorney did withdraw and was permitted by court. Yet, I understand the court allowed that, but as an attorney, that's a very big feat to step in the shoes of another attorney so close to the trial. So I feel that all of these arguments we're discussing today, we do need to take that into consideration overall with them and think, in the alternative, this could be an effective assistance of counsel. But the Brady rule provides that this exculpatory evidence must be provided to defense whether or not a request was made. The suppression of this evidence, it doesn't matter if it's willful or accidental. So long as it was suppressed, then that is the problem right there. And I do have a 3-part test, which is found in the United States Supreme Court in Strickler v. Green, which is 527 U.S. 263 in 1999. They reiterated the 3 components of a Brady violation. The evidence must be favorable to the defendant. Here, yes, the evidence was favorable. Had we gotten that Instagram post earlier, we could have brought that declaration in trial saying Mr. Peterson doesn't run his own social media accounts. Had we gotten the DNA evidence and not had to request that from the prosecution, we could have prepared for a better DNA argument, having the full picture. Had we had the testimony, the transcripts from Ms. Harris's interview, we could have countered that. We could have questioned her on cross about her interview. We also likely did not get fingerprint evidence on time. We did not get, and the fingerprint evidence actually showed that Mr. Peterson's fingerprints, were not found on that weapon. Currently, we are attempting at the Superior Court to have them run the serial number to identify the owner of the weapon, which was not done. And we are also attempting to retrieve either a recording or a transcript of one of the key witnesses' testimony one of the key witnesses in the case, Mr. Sean Hawley, who gave testimony, we're attempting to get a copy of his 911 call.
Wait, you said Sean Hawley?
Sean Kelly.
Oh, okay. I'm sorry.
Yes.
I thought you were referring to counsel who's female. Okay.
Yeah, no, very close. Yes, Sean Hawley was the attorney. Sean Kelly was the witness.
Okay, got it.
Different spellings also. So obviously we can see that this is favorable. The second question under that three-part analysis with Strickler was it suppressed willfully or accidentally? Yes. This evidence was suppressed. All of these different pieces to where Mr. Medesian said, I feel like every day I wake up and I have an email from either the night before or the morning of saying, oh, we missed giving you this. And very respectfully, I say that. And the final component of this three-pronged test is, would it have changed the outcome of the trial? Yes. Absolutely. If our jury could have heard the full picture, the full accurate picture of just the evidence being laid out as it was, without these don't be fooled and, late discovery, I feel that it would have really tipped those scales to reasonable doubt to find that Mr. Peterson was innocent. And that's why today we humbly, humbly pray for exoneration of Mr. Daystar Peterson.
Thank you very much.
Thank you.
Everything that she stated some stuff not correctly. Even the Instagram post, she didn't even relay the Instagram post correctly. She said something
Morning,
else
Your
that
Honors.
the
May it
post
please the
didn't
Court,
say.
Deputy Attorney General Michael Keller for the respondent. I want to begin by discussing the compelling nature of the evidence in this case. Within minutes of the shooting, the police found the gun that was used under appellant's seat. There were only 4 people in the car. Pete and Harris both identified appellant as a shooter. That first ID occurred within minutes of the shooting when Harris sent a text to a member of Pete's security team saying, "Help, Tory shot Meg, 911. Harris again ID'd appellant as a shooter in the recorded statement, and we can get to that in a moment. And Pete identified appellant as a shooter both before trial and at trial. Neither of them ever suggested that anyone other than appellant fired the shots. Now, there's 3 times in which appellant tacitly admitted being the shooter. The first is hours after the shooting, appellant made a recorded call to Harris stating that he didn't even remember what they were arguing about, and he wanted to know the hospital where Pete was being treated. He blamed alcohol for the quote-unquote shit that he did. Now, the second one was later that day, appellant sent a text to Pete, to the victim, and that text was preserved. In it, appellant said Pete would probably never talk to him again, that he was sorry, and he blamed again the alcohol for the quote-unquote shit that never should have happened. And then the third and final is the verified Instagram post that I'll also get to. Now, appellant's assertion is that he really wasn't accepting blame for having shot Pete, but for causing a rift in a relationship between Pete and Harris. And that's just nonsensical. First of all, Harris told the appellant she was at the hospital waiting for Pete. So if there had been a momentary rift that night, it was over because she's now at the hospital waiting for her friend that she's known for 7 years to be released and checking on her. Second, appellant didn't apologize to Harris, but yet he anticipated that Pete would never talk to him again. He was clearly accepting responsibility for something very big, something that applied to Pete, but not to Harris. And as appellant said he couldn't remember what they'd argued about, he wasn't accepting blame for anything he said. Finally, appellant said that he expected to receive backlash once word got out. Now, backlash for causing a rift makes no sense, but backlash for shooting someone does. The evidence in this case was compelling. Turning to a few of the issues that have been highlighted here today, I'll start first with the Instagram post. This was appellant's verified account. And A few times today I heard opposing counsel mention Brady, but Brady was never mentioned in appellant's opening brief or the reply brief. It can't be raised for the first time at oral argument. And frankly, it has no application here because the things that were turned over were inculpatory, not exculpatory. So when it comes to the Instagram posts, they were turned over upon realizing them, and there was no, many of the case, as you'll see in the respondent's brief, many of the claims that appellant raises are forfeited by a lack of objection at trial. And one of the things Your Honor asked is, did counsel ever ask for redaction? I don't see that anywhere in the record when it came to the Instagram posts. In fact, counsel didn't even object on the discovery basis. The objection was solely based on foundation. So discovery doesn't work for appellant on appeal. And as to foundation, the question really is whether or not there is an inference that can be drawn that a statement was made by a party. If so, it falls under the party opponent exception to the hearsay rule. And in this case, it's a verified account. And the fact that there may have been somebody else who had access to it to respond and may or may not have had permission, that would all go to weight, not to admissibility. Turning to the issue raised about the Harris recording.
Let me ask a question about the Instagram post before you move away from that. And I guess the question is, if there were some sort of error in admitting that post, what would your argument be about as to whether that was prejudicial or not?
Yeah, it certainly wouldn't be prejudicial, Your Honor, because first of all, at trial, it came out about these other aspects. In other words, do we know for sure whether or not this was appellant personally authored or approved of it? There's some question about it. But what we do know is he did send the text. What we do know is he did make the recorded phone call. Like, that's his voice. So, and by the way, I would say that on the Instagram post, the post, all it said was Harris didn't do the shooting. He didn't say, I did the shooting in that. So it's no more incriminating than the other admissions that came from his phone in a text or in person in a voice recorded call. So turning to the tape recorded statements that were made by Harris to impeach her as prior inconsistent statements. When she was on the witness stand and made a number of inconsistent statements, the prosecution impeached her with those prior statements. Much of the recording, pieces of the recording came out during that period of time. While she was still on direct exam, the prosecutor announced a desire to play the entire recording at a subsequent time. And that was that's 5 RT 3664 through 3665. Now, this puts the defense on notice that the entire recording is going to be played. The defense has an opportunity to object to it, to portions of it, and counsel doesn't do so. Counsel instead has an opportunity then to cross-examine on anything and everything that's in the recording because counsel knows that the entire recording is going to come in. So a confrontation clause claim just doesn't lie. And then I would add that on top of it, Harris wasn't excused as a witness. At the end of Harris's testimony, I see nothing that would preclude Harris from recall. So a confrontation clause is for when the defense doesn't have an opportunity to cross-examine a person on it. Harris testified, although Harris initially took the fifth, Harris was given immunity, subsequently testified. So the confrontation clause just does not work on appeal. And lastly, I'll turn to the allegations of prosecutorial misconduct. On that, again, these are forfeited claims. Objections weren't raised. Your Honor asked a question about how do we know on good faith, bad faith versus, there was a body attachment. You have a prosecutor that is, because the trial court did inquire into it, and the prosecutor said that the witness was under subpoena, and the prosecutor said they had a good faith. That's a judgment for the trial court. Now, I would note that if the defense counsel wanted more information about it, that was the time to raise it and to try to develop more details right then and there before the ruling as to whether or not this witness was going to be available and whether the prosecutor actually had a good faith. And the defense's failure to do so precludes the claim from being raised on appeal. And one of the things I'll note that is in the reply brief as to these allegations of misconduct that weren't raised below, the reply says, well, an objection would have been futile because it would have run the risk of highlighting the issue for the jury. That's not what decisions involving futility involve. The futility exception applies only if the record shows that the objection would have been overruled or that nothing could have been done in a curative fashion, not just that it might highlight an issue for the jury and the attorney had a tactical reason for not doing so. Unless the court has any questions, I'm prepared to submit on the brief and ask this court to affirm the judgment.
We have none. Thank you very much.
Thank you.
Any rebuttal?
Yes, briefly. Regarding the text to Mr. Edison, there was actually a motion in limine filed regarding that text. It was filed on December 12th, 2022 by Mr. Medesian. He stated that without Mr. Edison present in trial and without the foundation laid, that this text message shouldn't be admitted. That objection also was not granted by the court, but was on the record nonetheless. I've heard the people say that there was not compelling evidence, or there was compelling evidence, excuse me, to find Mr. Peterson guilty, but I argue that there was not enough evidence because we talked about the physical evidence in this case and the lack of physical evidence in this case. We discussed the variance in testimony where even today, it's still not quite clear what happened on that night. And I also want to talk about the Instagram post. The fact that Mr. Peterson didn't say, well, it wasn't Miss Harris and it was me, that really doesn't matter. There were only 4 people present the night in question. One was Mrs. Pete, one was Mr. Smith, who was the driver, leaving only Mr. Peterson or Miss Harris in possession of that weapon doing the acts that we're here for today. Therefore, it doesn't matter if he didn't confess. It was an implied confession because there was no question as to whether Mr. Smith or Miss Pete ever did these actions. I would like to remind everyone that Brady is willful or accidental. Brady says that regardless, the defense has a right to the evidence that's being produced against them in court. The incidents were very significant. The pieces that we were not given would have changed the outcome in this trial. For example, with the Harris recording, there also was an objection there for the Harris recording. That goes back to our motion in limine on December 5th. And in that, when there also was a sidebar as this was going on and these statements were being played to first refresh Ms. Harris's memory, Mr. Medesian did object and there was a sidebar and the judge actually commented that it's just easier this way. And Mr. Medesian said, but procedure. And the judge said, no, it's fine. We're going to do it this way today. So those objections were raised in the courts. Those weren't waived. And honestly, as far as recalling Miss Harris, there was no body attachment. She stated, I don't want to be here. I don't want to do this. She stated, I have not been truthful. And that's, I can't speak for Mr. Medesian. So there is no record of why or why not she was not recalled. But I feel that the people did just make a good point that it was futile. I feel that at this point, Mr. Medesian very respectfully did feel defeated. He did feel overwhelmed. He stated in his objection, I wake up every day and have an email from late last night or this morning with another piece of evidence that the people forgot to give us. And I do feel that he lost some of his steam there, so to speak. And because of that, that's why I reminded the court that he had that very short time to prepare, and any objections that were missed should be construed as ineffective assistance of counsel. And in that, I submit.
All right. Thank you both very much. The matter stands submitted.
All right, y'all. So that is the oral arguments, and they will later post the results. Now, y'all know I like to tussle, and these looks that I was given was to comments in the live stream. Now, being that this video, I'm going to condense it only down to the oral arguments and take off the other ones. That's going to mean the live chat is going to go away. But just know that some of those looks was to some of the people in the chat. Some of those looks were to some of the things that the lady said that didn't make no sense. But y'all know I like to tussle. So with that being said, let me drop my StreamYard link in the chat for anybody who wants to speak about what we just heard. Now, I found it interesting in the argument. Somebody, one of the things that somebody said is, girl, why you making all them looks? How much are they paying you? I can't be bought or paid for other than by YouTube and all of that. I don't get paid to go with anybody's narrative. I have my own mind. I was at the trial. I listened to the arguments at trial. I saw how things played out in the trial, and I was there. Did I say it already? At the trial? Yes. Okay, boom. So with that being said, let me drop the link and go any further. So some of the looks that I was giving is because some of the arguments that she was making were not to my recollection at all. She said her argument about the Kelsey statement being brought in. The reason that they brought that statement in is because Tory's team kept implying that the reason why Kelsey changed up and she started to say, I don't remember, I don't recall, they were trying to say that it was because the prosecutors were intimidating her or pressuring her, or what was the word that they were using? They were trying to make it seem like they were like, she was scared of the prosecution, and that was the reason why she was acting like that on the stand. So for the jury, in clear transparency, they brought that in basically as a defense of, no, that's not true. She's suddenly acting like that because something else, because here is the tape, and you can hear how we didn't intimidate her. She remembered everything. She was going over everything. She was recalling everything. She was making sure we were clear, and that's why that was introduced into evidence in full, because Tory's lawyer kept implying that they did something improper, or coerce is the word that I'm looking for. They were trying to make it seem like they were doing something like that. So they were like you trying to make it seem like this ain't what it is. So let me play it for you in full so you can make your decision. Do you believe Kelsey 2 months ago, or do you believe Kelsey here? And that's what the jury had they had a job to basically do, is to say, was she being truthful here? Did they intimidate her here? Or is she being truthful on the stand where she suddenly doesn't remember everything? But now there's all this talk of bribes, payoffs, him paying them off. They asked her on the stand, who paid for your lawyer? Was it Tory Lanez that paid for your lawyer? And she don't remember. She, all of this stuff. So they played that in full so that the jury can see what come on now. 1 + 1 = 2. Now, also too, when she relayed the Instagram post, she said the post said, I can't even remember. I should have wrote it down, whatever she said. I have to read back. But she didn't even relay the post correctly. He said, let me just pull up the post. How about that? Because she didn't even relay the post correctly. She said something else that the post didn't even say. So I'm like, wait a minute. She didn't even relay that correctly. So that was one of the reasons why I made a face, because I'm like, wait, what? That's not how the post, that's not what the post said, And then her argument was they didn't have the transcript for Kelsey's statement, but they had the audio. So it's not like they didn't know what she said. They had the audio. So was it typed up? Did they have it typed up? But they had the audio. They had that information. But let me pull up. I think I have it on this computer. If not, I'll have to email it from my laptop. But it was some things that she was saying that she was not relaying it based on what happened exactly. She was kind of twisting things a little bit, if you get what I'm saying. So, but Mel, what's your thoughts? What did you think about her argument?
Oh, hey Nick, how you doing?
Hey, how are you?
I'm good. Oh, I just wanted to say, listen, I can't even stay long. I'm having lunch. I want to say congratulations. You did a good job. I'm loving the show, watching it from my phone. And that's it. That's all I want to say. I didn't want to go into full detail, but I did text you.
Okay, I'm going to check it out. Thank you.
Yeah, but keep up the good work, sister. Keep up the good work.
Okay. Thank you so much.
Right.
All right. Oh, sorry to cut you off, Mel. All right. If there's anybody else who wants to come up, click the link. And what do you guys think? Even if you team Tory, team Let Him Go Free, because again, I like his music, but I mean, when I was there, and then also too, another thing that I wanted to talk about, the arguments on Tory's defense keep changing, right? They keep saying Meg was not shot. Then they say she was shot. Then they imply that Kelsey shot her. Now she's saying that, okay, it was 90% male contributor on the gun, right? There's only Kelsey in the car, Tory, Jaquan, and Meg. Even if we're going to die on the hill of the DNA, if it's a 90% male contributor on the gun that also stated that the DNA was inconclusive, okay, where does that leave Kelsey as the shooter? Also, he had GSR on him. She had GSR on her. So that's why there are other evidence that you can consider. They don't just consider one piece of evidence. They consider collective of evidence. They consider circumstantial evidence. They consider physical evidence. They consider testimony, and they consider all of these things. In the direct evidence that they had GSR on Kelsey. They had GSR on Tory. they did not have GSR on Jaquan. And Meg, are we saying that she shot herself? I don't think that we're saying that. And so also the what was the other argument that she said? Let me see if anybody clicked on. Okay. There was other stuff that I wanted to go over as well. So we'll see how this plans out. The Instagram post, from my recollection, was admitted because they were saying that that was him that made the post, and it came up in trial about it being not him that posted it. They talked about these things at the trial, but I'm trying to see. I'm probably gonna have to grab my laptop and email myself. But let me see if I could just Google it real quick. But it was just a few things that she was saying that was not the same. Let me just Google it real quick, because I gotta all my exhibits for the Tory case is on my other computer. Child. Click the link then. If you know every fucking thing, Miss Regina, Miss Real One. I'm a real one. Us real ones know. Click the link, honey. Anyways, so this is the post right here, but they were replying to, what's the main post? Somebody was saying that Kelsey shot, and he said that's not true, okay, from his verified account. Okay, and this is the actual post right here. Hold on, let me pull it up. All right, so this is what the Shade Room posted. And it says, this goofy AN say he ain't shoot her. And they literally have matched the bullets from his gun to the ones in her feet. And then somebody in the comments say, people saying Kelsey shot her. And Tory, from his verified account, says that's not true. Now, in addition to them saying from his verified account, him or his content manager saying that that's not true, why would, even if it wasn't him, somebody that's authorized to post on his account say that it wasn't true? And she's the only other person that they're alleging was culpable of it. So if it wasn't her and only him and her had GSR by us knowing in court, then who was it? Let's say it wasn't Tory that posted it. It was his content manager. You think his content manager is going to post something that he didn't approve of to be posted? And if it's his content manager, why is he saying that it's not true? Make that make sense. Somebody said Tory coat is full swing. Yes, child. It really is giving coat at this point. Like, it really is giving coat at this point. It really is giving coat at this point, because they're hanging their hat on one thing when there's other evidence. The main contributor of the DNA on the gun is male. That just means let's think about this. Let's think about this. There's the text that Kelsey sent within 5 minutes of the shooting saying 911, Tory shot Meg. There's this content manager that says Kelsey did not shoot, and it wasn't true that she shot Meg. There's the text message. There's the jail call. There is the GSR on the person of Tory and Kelsey. There's the testimony that Kelsey gave before trial, and there is the evidence that there was testimony where they talked about bribes. Now, with all the evidence, they're hanging their hat on the DNA of this gun. If the DNA is 90% male and there was no GSR, let's say the DNA not Tory's, right? DNA not Tory's, even though it's inconclusive. DNA not Tory's, even though it's inconclusive. DNA not Tory's. The contributor of the profile is 90% male. The only people that had GSR on them were Kelsey and Tory. So if you're on the jury, Kelsey is not a man. She's a woman. You have evidence that Tory or his content manager said that she didn't shoot Kelsey. You have text messages from Kelsey right at the shooting. You have body cam footage of their interaction. You have the fact that Kelsey is consoling Meg there. You have all of this other evidence that paints the picture, not just the DNA. Let's say that the DNA wasn't his. It wasn't Kelsey's either. But yet, Kelsey and him had GSR. But yet, and in closing arguments, I feel like the prosecutors made a compelling argument when she said, unless Kelsey, who has no criminal record, who has never been in trouble with the law, who has not even, been in trouble, and unless she's this criminal mastermind, why would she, is she, and basically what the prosecutor was saying in their closing arguments was, unless she's this criminal mastermind planning this shooting ahead of time and all of that, there's no way that she would text, help, Tory shot Meg, and be able to think of something so elaborate when, that's just not, come on. That's just, come on. And the gun was under his seat. It was hot to touch under his seat. A lot of people keep saying, why does she need immunity? There was allegations of a bribe being paid. Y'all remember that? There was reasons why she could have been in trouble other than shooting Meg. They asked her on the stand about her lawyer, about payment. They asked her about those things. There's other things that she could have been in trouble for other than other than that and hold on, let me see. I gotta get my evidence. Hold on, wait, because there was other evidence that was. Hold on, one second. Kevin, hello, are you there?
Hello?
Yes, your thoughts. Hold on, I'm still here. With your thoughts, I gotta grab my laptop.
My thing of it is, why did Kelsey have GSR on her if Kelsey didn't have the gun, or if Tory was grabbing the gun from her? Why does Kelsey have GSR on her? That's the question that people need to answer.
Well, they answered.
No. You keep skipping over that part.
No, I'm not skipping over that part.
Yes, you are. I never heard you say why do Kelsey got gun residue on her? Why?
Well, are you done?
Yes.
Okay. So at trial, there was a gun expert that testified. And due to the positioning of Kelsey standing next to him, they explain that GSR travels and there's blowback from GSR.
No. But hold up. They said Tory Lanez was behind the driver's seat. This what Megan said. Tory was behind the driver's seat, shooting across from over the car. So it doesn't even make sense. It doesn't make sense. Y'all got to stop with that.
No, y'all
Megan
got to stop.
I said no. Let me speak.
No.
I seen the video. Let me speak. Can I speak? Let me finish speaking.
No, you can finish speaking, but no, hold on. Y'all got to stop cherry picking facts, because my whole thing is, if you're going to relay something,
Megan was on the video on deposition saying that he was sitting on top of the thing shooting across the car. So what are you talking about? Y'all have to stop and really think about what's going on.
Did you hear the testimony of the gun expert?
No. We talking about Megan.
No.
Let's talk about Megan.
Did you hear the testimony?
Let's talk about Megan. Megan said in the deposition, Tory was shooting over the car. So how is Kelsey gonna be? What Kelsey doing with GSR on her? What she was grabbing a gun from Tory? What was Tory grabbing a gun from Kelsey? Because the guy who seen the fight said they was fighting first. Tory came around the car, tried to grab her because Kelsey had the gun. Kelsey was the one who did that. Y'all need to stop. Y'all got to stop with that. Y'all need to stop with this. Seriously. Because it doesn't make no sense that y'all want to keep this man in jail. For what? That girl lied.
Ooh,
and that's all I gotta say. Bye.
No, don't hang up. Don't hang up.
No, that's it.
No, don't hang up. No, where you going? Where you going? Don't get on here popping your collar, and then when it's time for me to respond, then you want to run. Don't run now.
Roll.
Hello?
Sad. So sad.
Girl, these people it's giving coat at this point. But anyways, my problem is that people pick and choose pieces and they ignore the complete picture. If you're going to pinpoint one thing, and they will die on the heel of one thing, but all of the other things that paint the actual picture, they excluded. Oh no, we're not gonna listen to the GSR expert. We're not gonna listen to the fact that you need 6 pounds of pressure to shoot, and it's impossible for it to be a hair trigger gun and it didn't just go off the way that they're saying. We're gonna ignore all of that. We're gonna ignore that GSR travels. We're not gonna listen to that. We're gonna ignore all of these things just to die on the heel of one thing. Child, what's your thoughts, girl? It's giving headache.
It's a big headache. Hold on. I'm back at work. I haven't been able to get on your live like I want to. Congratulations on your sobriety. Congratulations on everything. But the fact that somebody We'll sit and look at these details of this case and try to act like free Tory. He has made every chance to get out, from getting jumped in jail to everything. He is not focusing on like, I was there, this is what happened. I know for a fact this girl did it. He apologized for doing something. It's crazy that people want this man free and keep supporting him, trying to get different avenues. It's no different from a dog trying to get out of a hole. They're gonna figure out every way to get out the hole. Blame it on this person, blame it on that person. He did it. Because he did it.
It was
He
the
gonna figure out a
appellate
way.
attorney saying that what did she say, the last sentence about that only left, it was 90% something, that only left him and Meg. I'm like, what happened to Kelsey? But anyway.
And then if there's GR residue on both of them, Kelsey clearly was trying to help her friend when what was going on. So maybe that's how it got on her. Who cares though? Who cares? He's the one who said that he's apologizing for the shooting. Then he's saying he's gonna take the rap for Black women. It's full of crap. Why would somebody keep playing with somebody like that? Why would you guys want to keep listening to somebody who changes up how he can get free? He was already on probation. He just needs to sit in jail. That's it.
Child.
Okay. I gotta get back.
All right,
I gotta go back to
Julius and Lottie. I see you in the comments. Everybody who keeps claiming that he was apologizing for how things went down, again, that does not make sense in the context of the conversation. It just does not. It just doesn't. Like, you have to ignore the context of what he's actually saying to make that be true. He says he didn't even remember what the argument was about. So how can he be apologizing for the argument on the phone? That does not make sense. Again, I will replay everything. I have my hard drive with all of the evidence. We can run it back. I got time today. But the fact that people always say, oh, well, he was apologizing for sleeping with two friends. How is he apologizing for sleeping with two friends when he says on the call he don't remember why they were arguing on the call?
And he locked up.
He said, I'm the only person that's going to get backlash. Oh, they're not going to be, it's not going to be on Meg. Oh, I'm the only one going to get backlash. I got so drunk. I don't even remember what we was arguing about. So if he don't even remember what they're arguing about, how can he be apologizing for arguing about fucking friends? That don't make sense. But anyways, go ahead, Julius.
So my thing with this is people are forgetting that prior to the court case, everybody already mentioned Tory did it. Tory even said Kelsey didn't do it. So he already took her out. He already mentioned that she didn't do it. So that's why I'm confused when everybody's trying to say he's innocent. But I'm like, everybody who was there at one point in time said Tory did it.
Well, according to them, according to the internet, he didn't want to be a snitch. Even though he pointing the fingers at her now and snitching if she did it, but he
everybody
don't
else
want to be a snitch,
did
though. That's
snitch,
why.
and nobody ever snitched on anybody else but him when it came to snitching, because nobody wants to lie. See what I'm saying? Nobody, even he didn't want to say himself, but he told on himself once he said Kelsey didn't do it. So why would people argue with the victim about who did it when he said she didn't do it?
And the driver who was right there claimed he didn't. You mean to tell me your driver is there? He don't even see who shot?
And he don't want to make it out and see that you're losing your case to let him know that Kelsey did it.
But now
and
all of a sudden,
if you don't want to be a snitch, then just go to jail. You stay in jail if you don't want to snitch. That's what you're going to stay in jail for, like Little Kim.
But the whole thing is the driver is submitting a declaration now after the fact to say, oh, well, I seen Kelsey holding a gun, but, you know, when five shots got to ringing, you hear one shot, you going to turn and look. You're there.
It's okay if he saw her with the gun. He ain't see her shoot it. And Tory said she didn't, so she's still covered.
But
Tory
that's what
already
I'm saying.
said she didn't.
They don't
he said he saw her with the gun, but guess what? Now we're going to go with y'all logic that he didn't say she shot it. So once again, it still go back. Everybody did say Tory did shoot it. Even the white neighbor said Tory shot.
Correct.
There was not one time anybody said Kelsey shot. It's always confusing if Kelsey did it, but it was always for sure Tory did it. Kelsey even put it in the text to somebody when it all actually happened. He was blamed immediately when it happened because of Kelsey.
Right. Somebody said facts. He claims he was covering for Kelsey. Well, N-word, what they say, stand on
Sit in jail.
business. Then,
Yeah,
and
stand
do
on
your
business.
time.
Stay in
Right.
jail if you cover for case. That's what I'm saying. You can't, if you snitch, you should have been did it. Now, what's the point of snitching now? You say do the crime. You can't tell. You already said Kelsey didn't do it. You don't want to tell on her, so sit in jail, and then you going back to Canada right after.
Right. All right. ATG. Stay on, Julius. ATG.
Yeah, can you hear me?
Yeah, I can hear you.
Okay, yeah, I wanted to come on and let you know that you ain't crazy. Because these people trying to make you seem like you're crazy. You ain't crazy. Because they definitely are picking and choosing the evidence that they want to go for. Why would he come up here and say, why was the gunshot residue found on Kelsey if she didn't shoot the gun? It don't defend Tory if you're not listening to the trial and the evidence. That's exactly what that is. You want to defend him, but you ain't listening to nothing real that's going on. Like you said, they already explained that. She was next to him, most likely when he shot, and that was it. Then right afterwards, she gonna text, Tory shot Meg. What more do you need? I'm confused by these people.
She a criminal mastermind, so she planned it out, and she was planning to pin him 5 minutes later after allegedly shooting her best friend.
Right, let her win then.
Yeah, that's great.
Let her get this far. Let her win.
Yeah, that's crazy. And he definitely paid Milagro, whatever her name is, that blogger, to slander Megan. Because she was sitting up here slapping them every piece of evidence that they said against him. She gonna go against the grain. Just slap them. So yeah, the evidence is there. It's there, but people want to keep acting stupid.
Too, the cult also, they could never answer me this. If Kelsey shot when the father, whenever the father went and had any outburst, he never put any blame on Kelsey. He always was mad at Rock Nation and Meg. But why nobody mad at the shooter?
Exactly. Kelsey hanging with them.
Right.
And y'all know she did it. And y'all hanging out protecting her.
That makes no sense. Golden Girl, what's your thoughts?
Yeah.
Ooh, child, I'm so tired of these delusional Tory people. You literally just explained what you witnessed at the trial yourself about the GSR getting on Kelsey. And the guy that got up here and was trying to challenge you, he refused to listen because it doesn't fit his narrative. That's just ridiculous. And any logical thinking person would sit there and look at the events, how they were laid out. This fool called Kelsey, so you're going to sit up on a jail call. You're going to waste your jail call on the alleged shooter? That's what you're going to do? Right. Make it make sense.
Because you're apologizing because you slept with two friends.
Right. Who cares if you slept with two friends? Even though she got
two friends.
And it's not, and like you said, in the context of what happened, that don't even make sense.
Not if you listen to the actual call of what's said.
Exactly.
Philly,
it makes no sense.
Witherspoon, you shook your head. What's your thoughts? But stay on Golden Girl, and you could go back. Go ahead, because you were shaking your head.
I was shaking my head because I don't know 2 men today, and I am 55 years of age. I don't know 2 men today that will go to jail for another person who got, especially when you're cheating. He's apologizing for cheating. You know how many men out here cheat with friends? That just didn't make sense to me. Then second of all, the defense put their own witness up there that put the gun in Tory's hand. People are forgetting that this man didn't have a bone in the fight, and he said that Tory shot the gun, the little man. That's exactly what he said. The little man was shooting everywhere. So we gonna forget he said that? No, that killed him right there. You know, people got to understand when it comes down to it.
They're saying that the prosecution, which in every single case that I've covered, they have to each side has to talk to the witness before they get on the stand. That's protocol. the guy, Sean Kelly, had not talked to the prosecution yet. So they're saying because they took their legal right to talk to him before trial that they coerced him, and that's why he said what he said on the stand.
I don't believe that. I
Anything
believe
to
that
fit
man
their
told what he
narrative.
saw. I believe that man told what he saw, and they wasn't expecting for him to say that. Now you trying to backpedal. You can't backpedal, and I don't know nobody who's going to take, especially he's from Canada. Why would you even risk your freedom for somebody that you only seen maybe twice? Because remember, it was the pandemic, so him and her wasn't that close where they was. He had to protect her. If anything, he would have been protecting Megan, because that's who we all see him with all the time, was Megan, not her.
Right.
That's why I was shaking my head. It just don't make sense to me that people keep saying that this girl shot. Well, I'm not getting ready to shoot my friend and somebody that helped me out through my hard times because of a man. If anything, we're gonna go ahead and drag him. We're not gonna drag each other. Even if they did fight, I don't see why she would have to shoot her.
And
He
mind
has
you, the lawyers knew she did it, so why they ain't say nothing at the case if they knew?
Right, and then you knew this when you was coming to trial. Why didn't you bring her, even say on the stand? Because everybody they put on the stand, to me, that Sean Kelly is the one that I went with all the way around the board because he didn't know nobody. The bodyguards didn't show up until the end when it was almost, they was getting ready to do their close the arguments or get ready to close the case out. Then he wanted to show up. You had too much time to come and say, no, I was there and I seen what happened. Nobody, an eyewitness came and said, well, this is what I seen for Tory. Nobody. Even their the person that came on the stand, which was Sean Kelly, put the gun in his hand. Once they put the gun in his hand, it was a wrap right there. There's nothing that nobody could say or do about that because the man did not know Megan nor Tory. He didn't get anything out of it, regardless whether the prosecutor got to talk to him or the defense. That was the defense witness. So what the prosecutor couldn't have challenged him. You know what I mean? You couldn't talk to him to make him say what he said because they never got to talk to him. So it makes no sense to me.
Yeah, well, the prosecution got to talk to him the day of testimony. And so because he talked to him the day of, they're saying that, he told him what to say. But I just wanted to highlight this comment. It says, they want us to believe that he was willing to give up his multi-million-dollar career to protect a damn assistant from going to jail. Mind you, an assistant that he had no respect for. He didn't have respect for the assistant. He didn't have respect for Meg. He was in Kylie face saying F both of them. Mm-hmm. Y'all both could leave and I'm going to stay here and be in Kylie face. He played in Megan face and her face, but now he got all the respect for her in the world, and he was willing to say, "Girl, F you, I'm trying to get with Kylie."
In his character, he been smoking drugs. He hit August Alsina. He was attacking that little white OnlyFans girl. Like she was recording him attacking her at her apartment. So he got that in him. That's his behavior. He attacked.
It's also funny how people forget that he got on. He did a live talking about how he did not do this, and she didn't have bullet fragments in her foot, and I guess the doctors was paid off too because. It kept, you know what I mean? This was all a stunt, but then when you get the X-rays and you see the bullet fragments, now people don't see that. You don't hear them talking about that. Where the bullet fragments come from? Because he said it wasn't none in her foot. He said it was glass.
The hospital if they lying.
So you can pick and choose what you want to hear and believe, but at the end of the day, does it really sound right to you? No, it doesn't sound right what Tory is saying in my book. I felt like when I heard it and I looked through the whole trial, it was a complete mess where he wanted to get up there and act like he was this innocent person. And we all know he was not innocent by far in anything he has done in his career. He messed his own career up.
He still could take Kelsey to court if she the one who did it. But you see, he not.
But if he allegedly was helping Kelsey out, then that would come up.
Exactly. He's still gonna stay there. He's still gonna have to stay there. That's why I'm like, either way, if he lied or not,
out his mouth and say Kelsey, you shot her, and you know that you shot her, and until he says that verbatim instead of trying to dance around alluding to it, save it.
And then it's going to look like she
His
lied
statement
because
was
he said she
wanted to
didn't do
say.
it.
Who was just
He stated he wanted to save 2 Black women that night. And on top of that, Kelsey, who allegedly should have been a gunman because she was the gunman, she got immunity because of what again? Because of other stuff?
Are you
What's the
asking a
other
question?
stuff?
Start over.
So Kelsey got immunity because why?
Well, it's under seal, but we cannot.
Exactly.
It's under seal, but that you can use context and understand that it's more than just the shooting. And they also raised that in the transcripts. If you look at the transcripts, they talked about that to the jury, and that was not contested. The prosecutor said the judge is not going to allow her to get immunity for shooting somebody and have somebody on trial. That is in the transcripts. That was said before the jury, and that was not rebutted by McDesian at all.
So when they get immunity, is this not because they want to not self-incriminate themselves?
There's
something in the trial there's something
bribery.
There's something in the trial. But they asked her about the bribery. They brought that up about her.
That was
about
the
him paying for her
biggest
attorney.
topic in the trial: bribery.
So that's the reason why she got immunity, because of bribery, because he paid for her attorney allegedly. That's what she needed to be bribed.
That's my best guestimate. I can't say for sure because
Look,
it's
so
under
when
seal,
you're
but that's my best
immunity in
I
a
can tell you
trial,
why.
guys, is when you can potentially admit to something that you've done wrong, not the bribery thing. They brought that up in a trial. She had to.
Right, but she can't get away with murder either way. That don't stop her from if she shot her. She still can go to jail, and Tory can tell and get her in jail.
Right. But immunity for not saying certain things in a trial. You guys know that when they go to trial,
She got gunpowder on her, and the security guard could have lied and said that she had the gun like he said. Remember,
why would she have gunpowder?
We already explained why.
Well, Tory had it too.
She was close to him, supposedly, because she was close.
And look.